The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law. Sensitive topics are discussed. Discretion is advised.
I'm Vinnie Politan. The subject of my investigation, the horrific, unprovoked, cold-blooded murders of 4 innocent students at the University of Idaho. It's the biggest true crime case in America and the biggest trial on our docket at Court TV. Here's the story. On November 13th, 2022, 4 University of Idaho students, Kaylee, Maddie, Xana, and Ethan, were brutally stabbed to death in their off-campus home in Moscow, Idaho. The shocking crime left the college town in fear as authorities searched for the killer. After weeks of investigation, police arrested the suspect, a 28-year-old criminology PhD student at Washington State University. This suspect was linked to the crime through DNA evidence found on a knife sheath at the scene, cell phone records, and surveillance footage of his white Hyundai Elantra near the victim's home. Prosecutors believe the suspect planned the attack, although the motive remains unclear. He's been charged with 4 counts of first-degree murder and burglary and maintains his innocence. Both sides now are preparing for the trial, and more information is being made public about the evidence and circumstances surrounding this tragedy. Now, one thing that you know about this case through the years as we've been covering it, and other people have been covering it as well, so a lot of the information coming out is very limited about the evidence in the case. We got some early on with the arrest warrant, but since then, you know, we've gotten little pieces from court hearings, and then when either of the parties file motions, sometimes there's information in there that's new information. Well, right now, we've got some of that new information, and this comes from a defense filing, right? So it's the suspect's attorneys who are filing this and making this information now public because they're looking for some relief. It's a motion to eliminate. They're trying to limit some of the evidence coming in. In grand jury testimony, Jade Miller testified as to the results of testing done on item Q13.1, a swab of the left fingernail clippings from Maddie Mogen, one of the victims in this case. The data consisted of a 3-person mixture in the fingernails of Maddie. 3-person mixture. So now we've got DNA from different sources, which brings us to the first question in our investigation. And it's all about this DNA. What does this DNA prove? What does it show? What does it demonstrate? Got to get to the bottom of this. Joining me, former homicide detective, host of The Interview Room with Chris McDonough. Chris McDonough is with us, and laboratory director for Pure Gold Forensics. She has more than 20 years of experience in DNA analysis, forensic DNA expert. Joining us from a lab where she works, Susanna Ryan. Great to have you both here. Susanna, I want to begin with you. 3-person mixture. What does that mean? What are the challenges? What are the limitations? What can you get when you have a sample that is a 3-person mixture?
A lot of that's going to depend upon the quality of the mixture. So it sounds like, you know, we have Madison's DNA, which is not surprising, and then at least 2 other contributors. Now, looking at this motion, the fact that multiple individuals were listed as sort of inconclusive tells me there's probably not a whole lot of data available for comparison. So it's probably a low-level mixture. Now, that could mean that the DNA arrived just through casual contact. As a person goes about their day, they can pick up DNA under their fingernails or on their fingernails, or it could mean something more.
I want to go to more information that we have from this motion, which I think will explain a little bit here. The data from that sample was, and then they redact the word, as to the suspect, the accused killer. Miller testified that the redacted word there, we think this is the redacted word, inconclusive, right? So they say in the next sentence that Miller testified that inconclusive means that an analyst is blank, again, redacted. I'm taking from that the redacted word may very well be inconclusive. Miller went on to explain that the likelihood ratio for the suspect, and then that's redacted. The suspect's inconclusive LR, likelihood ratio, is similar to almost every other person for whom an LR was generated. And focusing on his inconclusive likelihood ratio would mislead the jury, in that it applies that LR means that the suspect's DNA might be present in the sample. More importantly, the suspect has disclosed that through further independent lab testing, he is eliminated as a contributor to item 13.1. Okay, Suzanne, a couple more questions to you, then I want to get to Chris. So the LR, the likelihood ratio, what is that? What's the significance of that?
That is the way that we do statistics currently, and it is basically a comparison of two mutually exclusive hypotheses. So one hypothesis would be what we call the prosecutor's hypothesis, which typically is that the person's included in the mixture, and that is compared to the defense hypothesis, which typically is that person is not in the mixture. And the likelihood ratio tells you which of those hypotheses is more likely. So in this case, when we have what they're calling an inconclusive range, they're saying, I can't tell you whether this person is included or excluded. However, I think one of the issues that the defense has with this is that there are recommendations, sort of the scientific working group on DNA analysis methods, they've come up with a number of recommendations. And basically they say no matter what the likelihood ratio is, whether it's a small number in support or a small number supporting exclusion, you should still report that number. Instead, this laboratory apparently has a pretty wide range of inconclusive.
So make this make sense to me. Now they're saying that the suspect, the accused, has disclosed that through further independent lab testing, he is eliminated as a contributor. How could a different test now have seemingly a different result that actually eliminates his as a contributor? Is this just an interpretation of results, or is there different testing that could have been done? How could that be?
I think that probably the independent lab retested the sample, and perhaps they were able to get a little bit more DNA from the sample. Perhaps their guidelines allow for them to eliminate a person at a certain less than 1 likelihood ratio versus this lab. So this independent lab may have done some additional testing, concentrated the sample, done something to be able to get a little bit better of a result where they can say he's excluded, instead of the Idaho laboratory, which they're saying inconclusive, but reading the motion, it probably should properly be said as support for exclusion. They probably were in a less than 1 likelihood ratio level, which is actually support for exclusion.
Chris McDonough, let me ask you, so what does this DNA prove?
Vinnie, obviously DNA evidence would put somebody at a crime scene. However, when there is an analysis like this that comes back, inconclusive, it means the results aren't necessarily clear cut. So from an investigative side, that could be from a couple of reasons. I mean, like a sample was too small, maybe it was, degraded, maybe it was mixed up with other DNA, like in this case. So you couldn't get a solid match. So basically it's a shrug of the shoulders from the lab. And so as an investigator, you have to take that and say, okay, well, then we have to put that over here in the exclusionary column until we get some additional definitive evidence. And that's what they did by revealing it to the defense.
So, Susanna, the next question is, okay, if let's say he's excluded, or however we want to term it, right? It's you know, it's interesting to hear it explained because a jury's going to have to understand this. Is there a way to take those the two samples that aren't her and to determine any information about the source of it, whether it's gender, race, or identity?
You may be able to tell gender. So there are a couple of different markers that we look at that are indicative of males. So they're specific to the male. So we know, obviously we have Maddie, a female. If any of those other markers that are specific to a male pop up, then they can say there's at least one male present. But that would be about it. We don't use the DNA that we do in the forensic lab to do any sort of, ethnicity or racial background or, hair or eye color, any of that. That's all completely separate. So that would be the farthest we could go, is possibly saying that there's a male present.
And is there any other way to put it in a pool of potential people? Like, if you've got a sample like this, would you get enough information where you could run that information through CODIS and you may not get like one hit, but you might get thousands of hits? Does it work like that, or it doesn't really work like that?
So the samples that are eligible for upload to CODIS they cannot be too much of a mixture because we don't want to have thousands of possible hits to go through. And again, kind of reading between the lines here, it sounds to me that the data is really low level and probably not eligible for CODIS. It's good for comparison to other potential persons of interest, but not for entry into CODIS.
All right, Susanna Ryan, I'm so glad that you're able to come on this program and help us explain this and help us understand this. Chris McDonough is going to stick around. Thanks so much, Susanna. Coming up next, so what does this DNA mean for the trial?
I think you can have DNA on an object at a scene when you know about all of these other things and you don't find probable cause, because there are more questions than there are answers, and all of a sudden this one thing doesn't look as big.
The Court TV Podcast will return.
As to Mr. Kohberger, now, there may be, as you say, other people that creates concern or issues about that need to be investigated further. But I'm not sure that diminishes the probable causes to Mr. Kohberger if his DNA is found on a knife sheath found on or near the victim, who was stabbed with said alleged knife that would have been in said alleged sheath.
I think the most prominent question is, how did that sheath get there? And I think when you ask that question, I think you can have DNA on an object at a scene when you know about all of these other things and you don't find probable cause, because there are more questions than there are answers, and all of a sudden this one thing doesn't look as big. It doesn't look as everything pointing to it when you have the context around it. The magistrate didn't have to have every detail of the case, but knowing how many attempts to find a DNA connection there were, and it didn't exist, in Brian's car, in Brian's apartment, that there's no other DNA in there.
We know DNA is a huge part of this case. It's the foundation of the prosecution case, the DNA that's found on the knife sheath. But it's not the only DNA. We've talked about this in the past. There's DNA on a railing inside the home of an unknown male. There's DNA of an unknown male on a glove that was found on the property outside. And now we're talking about Maddie's fingernail clippings. And you've got a mixture of the DNA from 3 sources, one of which is likely Maddie, but then you've got 2 other sources of DNA in all of this. So the defense filed these motions to limit what the prosecution can say, but when you read it, you kind of take something else away from it. The suspect's inconclusive likelihood ratio is similar to almost every other person for whom a likely ratio was generated, and focusing on his inconclusive LR would mislead the jury That implies that the LR means that the suspect's DNA might be present in the sample. When the suspect sought to overturn the grand jury indictment, he argued that Miller's testimony was inadmissible and misleading. The state argued that the testimony, this is interesting, the testimony was presented to the grand jury as exculpatory and an effort to elicit favorable evidence for the suspect. The independent lab testing conducted by the defense related to this item is indeed exculpatory. The suspect is excluded, and the state should be precluded from misleading the jury in any way. So it's semantics about how they describe this DNA, but it seems clear that the defense has their lab looking at it and clearly excluding the suspect. So the DNA is from two other unknown sources. Brings us to the next question in our investigation. What does this DNA mean for the trial? The trial's coming up this year. Joining me, criminal defense attorney, the man behind the glasses, Josh Schiffer, is with us. Josh, every case, every trial is a battle, it's a fight. Things that seem small at one moment become very large inside the courtroom. What are your thoughts about the fingernails of one of the victims, Maddie? Two unknown sources of DNA.
Well, I think it's pretty clear. This is confusing. You're confused. I'm confused. I think that it's pretty clear that there's confusion in front of the court about how these test results are admissible or they're supposed to be interpreted. And we haven't even heard from the defense's experts, who I'm willing to bet have impeccable credentials and are going to come in and talk about other problems with these already inconclusive results. And the issue at trial becomes, well, are we going to let the jury know this exists, or does this just remain silent? Because the jury theoretically doesn't know anything. And that jury walks in not considering, unless they're using their outside knowledge from before the trial and just their regular life, that they might test under the fingernails for DNA. Otherwise, this might not even get mentioned. It might just be wrapped up in the rest of the state's case. So the defense is really pushing hard, and for the right reasons, to limit and exclude this as much as possible, because the mere existence of these testing results tends to confuse the jury. And I think that's very clear. Doesn't mean the judge is going to exclude it, though, because this is powerful physical evidence backed up by science.
Also joining us, former federal prosecutor, president of the West Coast Trial Lawyers, Nima Rahmani. Nima, should prosecutors presented this to the grand jury because they have an obligation to present potentially exculpatory evidence? That's one place in one scenario. In front of a jury, is the defense going to jump on this? Should the prosecution be concerned that there's unknown DNA in the fingernails of one of the victims, which, according to the defense, excludes the defendant? And I think prosecutors might likely agree with that, because they're the ones conceding that it's potentially exculpatory.
Many prosecutors shouldn't be concerned because there's so much other evidence in the case. But absolutely, you have to front this potentially bad evidence in the case. Look, it's a party house. There's going to be people coming and going. There's no evidence necessarily that the victim scratched or clawed the murderer, whether it's Bryan Kohberger or whoever is alleged to be the killer. So if you're the state, you want to get out ahead of all this other type of DNA, whether it's on the railing, whether it's blood, and you want to say, listen, Kohberger's DNA is on the knife sheath that we believe is the murder weapon. Unless it was transferred or planted, he was there. So the defense can make, kick and scream and talk about all the other DNA that was found. But ultimately, with all the other evidence in the case, this is just one piece that's going to put Bryan Kohberger away for life, or maybe even put him to death.
Josh Schiffer, we've watched and covered so many cases here on Court TV through the years. And when the defendant's DNA is in the fingernails of the victim, prosecutors jump up and down. Do you think the defense is going to jump up and down as Nima described here? I think they will, because again, they have some tough facts to overcome in this case, but they've got to latch on to something.
Yeah, if this evidence was standing by itself, then it would certainly be inappropriate because of its lack of consistency and the confirmation. It would be subject to the battle of the experts, and I don't think it would be admissible because how much we know juries are swayed by this kind of evidence. But taken with all of the other totality of the circumstances, this is just one piece of evidence that lends credence that he is one of the people that could have been there according to this DNA testing. That's in addition to the sheath. That's in addition to this being a party house. So the DNA is not the, terrible word, it's a smoking gun for the prosecution in this case. It's just one of the bricks they need. So the defense is going to fight this specific piece of evidence. Whether it's exculpatory, sure. I'll give it to the state that they used it in a way that is kind of sneaky in order to get it admitted in front of the grand jury. But we all know exactly what they're doing. They're putting Bryan Kohberger on the scene under her fingernails. That is a tone of habitat that is going to strike every juror.
All right, you guys are going to stick around. Got more questions for you, a lot more to cover. Up next, how reliable is Dylan Mortensen's memory, one of the surviving roommates?
Now, back to the Court TV podcast.
I'm Vinnie Politan. We continue our investigation of the brutal murders of 4 young adults who were killed in cold blood in the middle of the night at the University of Idaho. Here's the story. A 28-year-old criminology PhD student at Washington State University was arrested on December 30th, 2022 in connection with the brutal murders of 4 University of Idaho students. Kerry, Maddie, Xana, and Ethan. Investigators linked the suspect to the crime using DNA evidence found on a knife sheath at the scene. Surveillance footage was also found of his white Hyundai Elantra near the victim's home, and there is cell phone data placing him in the area. Authorities believe he may have stalked the victims prior to the attack. The accused killer has been charged with 4 counts of first-degree murder and burglary. He maintains his innocence and has pleaded not guilty. The case has drawn national attention, and now with both sides preparing for this upcoming trial, new details about the facts surrounding these brutal crimes are now being made public. A lot of the information that we have regarding this investigation has come out through some of the court hearings and some of the documentation, court filings, including the probable cause affidavit, which came out early in this case after the arrest of the suspect. And one of the big revelations from that was that there appears to be a witness, one of the roommates from inside the house, who actually saw the killer that night. Didn't realize that the person she saw was the killer because she didn't realize that there was a quadruple murder at that moment. But this was really like eye-opening, that, oh my goodness, someone survived in that house and someone saw the killer as he was leaving. So I want to show you part of that probable cause affidavit. And they referred to the witness as DM, which is Dylan Mortensen, the roommate, stated she opened her door for the 3rd time after she heard the crying and saw a figure clad in black clothing and a mask that covered the person's mouth and nose walking towards her. DM described the figure as 5'10" or taller, male, not very muscular, but athletically built with bushy eyebrows. And as we all looked at that description, we're all thinking it's consistent with, it's not a terribly detailed description, but it's very consistent with the suspect in this case. The build is athletic, but he's not muscular. He's relatively tall. And he's got those bushy eyebrows. Now, the defense has filed motions trying to limit some of this information, including testimony from Dylan. In this case, the description provided by DM, Dylan Mortensen, is unreliable and should be excluded. Although she has never identified the suspect, testimony by DM from the witness stand describing bushy eyebrows while the suspect sits as the accused at trial will be as damning as her pointing to him and saying, he is the man that did this. They are concerned that she's going to describe bushy eyebrows. Jury's going to look over, see the defendant and his bushy eyebrows. So it brings us to an important question in this investigation. How reliable is Dylan Mortensen's memory from the early morning hours of that overnight inside the home? How reliable? Joining me, former homicide detective, host of The Interview Room with Chris McDonough. It is Chris McDonough, and Idaho defense attorney who represented Chad Daybell. John Pryor is with us as well. Let me ask you, John, first, this witness's testimony about seeing someone with bushy eyebrows, and we've seen what he looks like. How much of an impact do you think that would have in a case like this?
Well, I think it's going to have a tremendous impact. If you go through the pleadings, you'll see that the young lady had a habit of drawing eyebrows as part of her artwork. That's what she focused on. Obviously, the defense is going to have the opportunity to say she was intoxicated, she was fuzzy, she acknowledged all of that. But the reality is, if that's her habit of observing people's eyebrows, and she sees an athletic man coming in who's over 5'10" with bushy eyebrows, it's going to have an impact.
Okay, so let's dive a little deeper into this, Chris, because there's a lot more in these papers that were filed by the defense. Okay, let's go to November 13th of 2022. Dylan is interviewed by law enforcement at the scene. She describes the intruder's height, build, and clothing, but says nothing about the eyebrows. Law enforcement took pictures of Dylan's room. On the walls in her room were many pictures, as John said, of eyes with prominent eyebrows. She had drawn many of them herself. Some of the eyebrows in the pictures are heavy, voluminous, puffy, or perhaps subjectively bushy. Detectives found artwork of human figures with an emphasis upon the eyes and eyebrows pinned to cork boards. Chris, what do you take away from this when you're trying to analyze the accuracy of her memory? One, in this interview in the 13th, there's no mention of the eyebrows, but then when you go into her room, there's apparently pictures and drawings of eyes and eyebrows everywhere.
You know, Vinny, that's not uncommon with eyewitness testimony in terms of, I used to explain to witnesses of, traumatic events such as this is just think of walking into a kitchen and seeing a very large puzzle of the Statue of Liberty, for an example. What you just experienced was somebody walking in and just flipping that table over. And now what I would like you to do in a narrative form is try to assemble those pieces one piece at a time. And so it's imperative upon investigators, and in this situation, this is not uncommon because, it's so subjective and at times it's going to be incomplete. You'll notice in the filing, this motion here, where we learned that she was intoxicated, she had a variety of type of feelings going on, and that she also remembered going down to the other roommate's room on the first floor, and she fell asleep for 8 hours, and that filled that piece of the puzzle in for the 911 call. And I don't think the investigators were expecting that during that interview. So, that's the point here about subjectiveness in relationship to an eyewitness. You've got to take your time, and they will fill in the gaps if they believe they actually saw it.
Now, talking about gaps being filled in, another interview on November 17th of 2022, 4 days later. Dylan tells detectives she was really asleep and probably very drunk when she woke up around 4 a.m. She expressed uncertainty about what she heard and saw and did not know if it was real or a dream. Dylan described seeing the intruder's bushy eyebrows, but could not describe the shape or color of the eyebrows. John, what are your thoughts here about the reliability of her memory as she starts to describe some of these other things 4 days later?
Well, that's going to be helpful to the defense. They're going to attack if she gets on the stand. And as far as the defense being able to have this excluded, I don't think the judge is going to allow it. But in terms of the defense being able to attack her memory, it's significant. But I go back to what your other witness talked about, which is she has a focus, and that focus are on the bushy eyebrows. And the fact the defense is bringing attention to just not allowing her to talk about bushy eyebrows shows you how important that piece of evidence is.
Absolutely. Absolutely. Okay, Chris, we're now moving forward to December 1st of 2022. Dylan tells detectives she did not see the intruder's eyes, but she saw one eyebrow or two, but it was just like this bushy eyebrow. I could just see like an eyebrow, this bushy eyebrow. She did not know what parts of her recollections were dreams and what parts were real. When she woke up that morning, she did not fully understand what was a dream or not. In this interview, she indicated that she thought that the person she saw was a fireman. How concerned are you, Chris McDonough, about the way she's describing her memory?
You know, Vinny, I think John's accurate, and I agree with him that in this situation, obviously, there's a lot of stress on board. And so for her memory to be bouncing around there, you really have to do what we would call a cognitive interview with them, with her, and really kind of narrow the scope. One of the things that I want to just mention here, I am a little concerned that there were three separate interviews from three separate detectives. Typically, in a high-profile situation like this, once you connect with a particular witness and they're such a value, you want to keep the same investigator interviewing them so that they pick up maybe these inconsistencies. But the defense may pick up on that. But I still think her power is going to be one male in that house and bushy eyebrows. That will be the power.
Now, on December 30th, this is after the arrest of the suspect. Detectives asked if the suspect was the person she saw in the house. She said she didn't know. All that she remembered is some bushy eyebrow and all black and some sort of a mask. John, what does your gut tell you about what happened, what she saw? Because she's saying fireman at one point. She's saying I'm drunk. She's saying I'm sleepy. She went to sleep afterwards. How trustworthy and how persuasive will her testimony be? And how much do you think it can be relied upon here?
Well, I think, quite frankly, it's going to be pretty reliable. You have a young lady who has an emphasis, or at least has an attraction to eyebrows. She sees a guy who has that athletic build. She doesn't remember a lot of anything else because she was intoxicated. Well, that happens with witnesses sometimes. She's sleepy. She was fuzzy. But she was clear enough that she saw someone with an athletic build. He was wearing dark, and he had bushy eyebrows. The defense, if this wasn't significant, the defense wouldn't be going through this motion in limine to exclude this. They understand, and they put in their own pleadings, that this is going to be significant, and it's going to be one of the significant pieces that, in all likelihood, is going to convict Mr. Kohlberger.
Unbelievable. Big thank you. Chris McDonough, John Pryor, great to have you on the program. Appreciate it. All right, still to come. How important will Dylan's testimony be at the trial?
There's the third interview, And there's references to not remembering, being drunk, a statement, I don't know any of it. Like half this stuff, I don't know if it's a dream or if it's real.
This is the Court TV Podcast.
Remember, the issue was whether or not one of the victims ran downstairs. And she didn't say it once. She said it 4 times in a row in the very first interview. And that just didn't happen. It just couldn't have happened. And that was not told. In fact, that statement was brushed over and withheld from the magistrate. About the memory issues in the second interview the same day, there are 2 references to not remembering. A couple of days later, there's the third interview, and there's references to not remembering, being drunk, a statement, I don't know any of it. Like half this stuff, I don't know if it's a dream or if it's real. That's at page 399. At page 406, I don't know if this was real or in my mind was just like playing with me. But from what I think I heard, someone was crying in the bathroom.
For a moment, think about what this poor young woman went through, right? She survived, but 4 of her friends were slaughtered inside her home. And she believes, and I believe, that she saw the killer. Wow. And now, you know, you're young, you should be living the best days of your lives, and this has to just be like hanging over her, a part of her life, day in and day out. It's not fair. Now, let's take a listen to the prosecutor with their position about Dylan's memory and her testimony and what she saw.
The simple answer is investigators knew what she saw was real, and we know it wasn't a dream because they found the evidence discovered the next morning. That general description, which is what was provided in the PC affidavit, was consistent throughout all of her interviews. She described seeing someone wearing all black, a mask with only a portion of their face showing and visible. This person was male, white. She heard a voice that was not something that she recognized. The person was a slim, skinny, lean build. And the person was taller than she is around 5'8".
That brings us to the next question in our investigation. How important will Dylan's testimony be at trial? Joining me, former federal prosecutor, president of the West Coast Trial Lawyers, Nima Rahmani, and criminal defense attorney Josh Schiffer. Nima, this is not an eyewitness to the crimes, but an eyewitness who apparently saw the killer. How important is her testimony?
Vinny, not that important. This is why, even if there was a definitive identification, there's all sorts of experts who would come and say how eyewitness testimony is unreliable. And here you have someone that has never been able to definitively identify Bryan Kohberger as the person in the house. And she won't be allowed to do it in court because that would be an unduly suggestive identification when she hasn't been able to do it already. Coupled with the fact that she's talked about her memory issues, maybe she was dreaming. If I'm the state, again, lean into the bad evidence. Get up there in opening and say, you're going to hear from Dylan. She was partying that night. She was drinking. She was sleepy. She said she might have been dreaming. She saw a white man, slim, bushy eyebrows, but she was unable to identify the person as Bryan Kohberger. Get her off the stand quickly and move on. Get all those bad facts out that you know the defense is going to try to elicit during cross.
Josh, how important will this testimony of the closest thing we have to an eyewitness in this case?
Yeah, you know, the state's really trying its best to keep this, the state's really trying to keep this information in while the defense is pushing so hard to keep it out. And that's because of the dispositive effect that a specific identifiable feature can be on a jury. When you make that kind of direct linkage with the bushiness of the eyebrows and then look at the defendant, it becomes something the state can focus on and anchor for a prosecution. But at the same time, I'm going to agree with my good friend Naima, where this is a bad fact if the defense wants to make it a bad fact. We've got these memory issues, the drinking, the partying, the lack of consistency. If the state overplays some of this information, the defense will rug pull them and basically go, look at what the state's trying to base their arguments on. Bushy eyebrows. When it just so happens, she had all this collection of bushy eyebrow art on the wall in her bedroom. And it's those little things like that that eventually create a wave that ends up at reasonable doubt. So if I'm the state, I'm not focusing on this at all. There's too much of a potential gift for the defense.
Nima, what do you think? How do you think the jury interprets that? Because I think there's a couple different ways you can look at it. The fact that there are apparently drawings that she's done of bushy eyebrows in her room, like not just one picture, but there's pictures around. And this defendant has bushy eyebrows. He does. There's no doubt he's got bushy eyebrows. But how do they interpret the fact that she's got this room with these images? Is that something that helps the prosecution or defense in this case? Because I can see it both ways.
It could go both ways, and obviously someone who has an affinity for eyebrows and knows eyebrows. But look, you talked about it when you started this segment, Vinny, someone who is going to be very emotional on a witness stand. I can't imagine the survivor's guilt and trauma that she's experienced, that she's the survivor. And ultimately, right, here's someone that didn't even call the police, right? So we know that that's a fact. And again, I'm not saying that Dylan did anything wrong, but you got to be careful how you present her if you're the state. You certainly don't want to put her first. It's a very risky type of witness that can easily break down on the stand because of all the different issues that we've discussed. And we know because of the very broad gag order that she hasn't talked to anyone, and this is going to be the first time since the beginning of the case that she's going to tell her story. So it could really go either way. So I would not focus a lot of attention on this witness. It's too risky, in my opinion, if you're the prosecution.
All right, we have 5 seconds left here, Josh. 0 to 10, how hard is the defense going to go at her on cross-examination?
Oh, an 8 or a 9.
Wow.
You don't want to overplay it, but
Gotcha.
You're going to beat her up on the drinking and the memory.
All right, thanks so much, Nima Rahmani, Josh Schiffer. Always great to have you. This trial will be intense. There is so much at stake, and it begins with justice for Kaylee, Maddie, Xana, and Ethan. Will the truth come out, and will their killer pay for his crimes? Anything less will be difficult for the families of these 4 students. Meanwhile, the defendant's defense team is facing a death penalty prosecution. It doesn't get any more serious. That's why every motion, every ruling, and everything that happens in this case is so crucial, and why we are always asking questions. I'm Vinnie Politan. We'll keep digging for answers as the investigation continues. There you have it. If you want to see more in-depth reporting on the latest true crime stories, you can see me every weeknight, 8 p.m. Eastern on Closing Arguments. Thank you so much for downloading. And as always, please don't forget to hug the kids.
This podcast is a production of Court TV. Go to CourtTV.com for more content, trials on demand, and to find out how to watch Court TV in your area.